Hey guys, this is Vijay Dinakar. In this video, I want to talk about how do you clean your criminal record in the state of California. So, as a little bit of a disclaimer, this is only related to California state law. So each state, every single state in the country, has their own criminal codes, as well as the United States federal government has its own criminal code. And so this video will only relate to cleaning criminal records that you might get in the state of California. The other disclaimer is that there are a number of different other vehicles for cleaning your record beyond those that I'm going to cover in this video. This is just going to go over the very basic ones that I typically see. There's also some additional ones. And also there's a lot more details in each one of these things that I'm going to talk about. I'll try to make an individual video for each of those. So just to begin with, how is a criminal record actually created? So the most obvious way is that somebody is arrested. So the police come for some sort of crime, whether it be a DUI, a domestic violence offense, a robbery, a murder, whatever it is, and an arrest is made. So an actual arrest record is created only when you are taken by the police, typically to the police station, your fingerprints are taken, your mugshot picture is taken, that information is transmitted to the California Department of Justice in Sacramento, and now you have an arrest record. So unless you do something after the fact, which we're going to discuss in this video, you will have a permanent arrest record. That arrest record will not somehow vanish after 5 years, 10 years, 20 years, 30 years, anything like that, unless the California law changes. So you have an arrest record at that point. Additionally, after the arrest, if the district attorney files criminal charges against you in court, now there is a filing record, and there is a record of what you were actually charged with in court. And then if you actually go to court, there's a record of what happened in court. So there's a local record that you can see by going to the county courthouse and seeing that the case was filed, what the charges were, what happened in each court date, etc. And then finally, if unfortunately after the case is filed, you go to court, you're convicted, meaning you're found guilty after you plead guilty, or you go to trial and you're found guilty, now you have what's called a conviction record. So those are the kinds of records we're talking about. Now, how do you know what you actually have in terms of criminal record, or if you even have a criminal record, period? Well, in California, it's actually very simple. So you can do it yourself by going to what's called a live scan operator. And there's many different private live scan operators that operate. Basically, they take your fingerprint. You give them a form, and I'll send a link in the description to where you would get that form. But you go with the form, they take your fingerprints, they send that to the California Department of Justice, and then they send you back a letter with your full official criminal record. So let's say you looked at that and you said, oh, I have an arrest record. And by the way, those records of what your official record is can actually be inaccurate. And there's a way to correct that, and I've done that for a number of people. But let's say you ask the other question, well, I have a criminal record. I know I have a criminal record, either because I know I was arrested or I looked at my live scan and I know I have an arrest. What is the reason I would want to get rid of that criminal record? Many reasons. First of all, jobs. So in the state of California, and again, this only relates to the state of California, but the state of California labor code law governs what employers in the state of California can consider when they're deciding whether to hire you, including what's in your background in terms of a criminal record. So if you have certain kinds of criminal records, the employer is forbidden from using that against you, whereas other records, they are perfectly able to use that against you, and we'll go through which they are allowed to and which they're not allowed to. So obviously, if you have two equally qualified candidates for a job, and one has a criminal record and the other has no criminal record, you would assume that the employer will tend to want to hire the one without the criminal record. So it's obviously very important not to have a criminal record if you're worried about jobs. The second reason I see a lot is immigration. So if you are here on a visa or green card and you get arrested or convicted of a crime, that can have serious, devastating, and irreversible immigration consequences. So if you're able to either reduce or erase some of those records, then certainly as an immigrant, that will be helpful for you. The other reason I see, or in terms of wanting to know whether you have a criminal record and why it's important to clean that record, is professional licensing. So if in the state of California, for instance, you want to become a licensed doctor, a licensed dentist, a licensed attorney, licensed accountant, there's all kinds of different professional licensing that you might want to pursue in the state of California. Those licensing boards are not governed actually in the same way that employers are. They actually have more of an ability to look at more records in terms of your background than employers do. But again, if you're able to clean up some of that criminal record, the licensing board will certainly take that into account and it'll help you. So that's worth doing before, for instance, you want to apply to become an attorney or to become a licensed accountant. You may want to clean up some of the record. Even if the licensing board will find out that the record was, quote, cleaned up, it will be helpful in terms of whether they're going to actually issue you a license. Another reason I see is that people are applying to college, graduate school, or a professional school. So colleges are not forbidden from using certain criminal records against applicants, and some of them do consider background, some of them don't. I think typically graduate schools may be more likely than colleges, although again, it would be more in the realm of professional schools, so law schools, medical schools, dental schools, those kinds of schools where ultimately if you go to that professional school, you're going to have to get a license. The school in advance may want to know that you have a criminal record. So for instance, I know for sure if you want to apply to law school, most law schools will ask and inquire about whether you have had a criminal record, because they know ultimately if you go to their law school and go through the 3 years of law school, then you're going to have to take a state bar, and the state bar, after you pass that exam, will want, before they professionally license you, to know if you have a criminal record. So the law school also wants to know that. Medical school also wants to know that. But again, if you're able to do some of the things I'm going to describe in this video before applying, then your chances of getting into that school are much more improved. The other final reason would just be that, as you might know, if you Google someone or you Google yourself or you just Google criminal background check, there's a number of public companies that will advertise for a price that they will do a background check on someone. Now, those background check companies often, unfortunately, first of all, are not necessarily based in the state of California, so they're not necessarily governed by California law. But secondly, they are often relying on outdated, inaccurate, and wrong information. However, pursuing some of these things in California court, first of all, could correct those records. And if you're having a friend or someone who you don't know wanting to do a background check on you, again, getting your background check cleaned will help that if they actually do a background check on you. So let's start with the whole idea of an arrest and how can you clean an arrest record up. So let's suppose you are arrested for domestic violence and the prosecuting agency declines to file a case against you. And the statute of limitations, let's say in this case, is 1 year. For instance, it's a misdemeanor that they arrested you for. Once that statute of limitations expires, or even before that, if it's determined that a case is not going to be filed by the district attorney, then the arresting agency must, and the words are shall, issue you a detention only certificate. What does that mean? That means that in your California Department of Justice records, official record, criminal record, the arrest will now be deemed, pursuant to California Penal Code Section 851.6, a detention only. So in that sense, as a matter of law, you're actually not arrested. Okay, so what you were detained. And so this happens all the time, where somebody's arrested for a crime. It could be a drunk in public. It could be a battery. It could be a domestic violence offense. It could be anything. And then the prosecuting agency, which in California is the local district attorney's office, decides not to file that case. And it's gone past the period where they're considering filing it. At that point, the arresting agency, perhaps, let's say the San Jose Police Department or the San Francisco Police Department or any local police department arrested you. Once they know that the prosecuting agency is not going to file a case, they're supposed to, on their own, issue you a actual written document that says this is a detention only, and they're supposed to notify the California Department of Justice that this former arrest is now a detention only. Now, do they actually do that? Answer, no. They rarely proactively do that. And some local departments are better at doing that proactively than others. Some never do that. But as a matter of right, you are entitled to this change in the designation from an arrest to a detention only. And I've helped a lot of clients get this. So what we have to do ultimately is show the local arresting agency, after I write them a letter, that this case was an arrest, when it occurred, and that this did not result and will not result in a filing by the district attorney's office. And therefore, they're entitled by law, and there's actually published case law on this question, to an arrest, to a detention-only certificate, and that they must contact the Department of Justice to change that. So that will help in all domains. So you will then see a change in your live scan official record from the California Department of Justice. And by the way, that outcome that you can get for a detention only is a standalone remedy. It can be obtained whether you can obtain any of the other things I'll talk about or not. Okay, the second thing I would want to mention is, and this is the best outcome you can possibly get with regard to an arrest in the state of California, and that's a factual innocence finding. So California Penal Code Section 851.8 says that if you are arrested and the district attorney does not and will not file the case, and there's a period, a statute of limitations question where you can't file this yet, okay, but let's say they don't file the case in court against you, and the appropriate time has expired by which you can then file this motion. You file this with originally the arresting agency. So let's say the San Jose Police Department arrested you, you were arrested, the district attorney is not going to file the case. Now you have to send them notice that you want to have a factual innocence granted. They have 60 days to respond. They will never say, yes, we concede that there was no reasonable basis for the arrest that we made. And that's the standard. There must be a showing by the person who was arrested that there was no reasonable basis for the arrest, and the burden is on the person who was arrested to show. That's a very difficult thing to show. But anyways, the arresting agency will not concede that they made a wrongful arrest. So they'll ignore that routinely. Some of them will even respond with a letter saying, no, we disagree. At that point, however, you can file the request for factual innocence in court. And then you have to serve a copy on the district attorney. And what I usually want to do is, and this does happen in some circumstances, after I file the motion, contact the district attorney who's actually going to be handling this request and try to convince them that, hey, you guys didn't file this case and there was no reasonable basis for this arrest, so don't oppose my request for a factual innocence finding. And if they agree to that, the judge who is ultimately responsible for making this finding will agree as well. So I can't imagine a case, I've never seen a case where both the defense attorney representing the arrestee as well as the district attorney's office are on the same page as far as granting the factual innocence finding, and then the judge opposes it. So he'll grant that. And then this is the circumstance that could exist if the district attorney does not file the case. However, if there's an arrest, the district attorney does file the case, and then the case is subsequently dismissed with no admission whatsoever of guilt, then also at that point, the arrestee is eligible to have their matter be deemed to be found factually innocent pursuant to this remedy, and they can also proceed the same way. So again, they file the motion. Now they don't have to file it with the law enforcement arrestment agency first because the case has already been filed, but they file it with the DA. If the DA agrees, the judge will sign off on it. If the DA does not agree in either of those circumstances that the person is factually innocent, they will oppose that motion, and then there will be a hearing. And at that hearing, actually the statute allows for basically any kind of evidence to be brought by both sides. So that includes police reports. So you can actually, as a district attorney, simply submit a police report to the judge, which you normally could not do in a normal jury trial. So you can submit hearsay evidence. You can submit written statements. You can also submit and have live testimony taken. And I've seen all of these occur in contested factual innocence hearings. You can even submit evidence which would otherwise be excluded because it was unlawfully obtained. So you normally could not ever bring into evidence as a district attorney evidence that was illegally obtained, but in a factual innocence finding case, you can at the contested hearing. So now, let's say you win, either because the district attorney doesn't oppose it and you get your factual innocence granted, or the judge agrees with you that you're factually innocent because there was no reasonable cause for the arrest. What happens then? Well, then all of your records, including the record of the filing for the factual innocence, including the local law enforcement records of your arrest, including all of the Department of Justice records that have been gathered vis-a-vis this arrest, are sealed entirely for 3 years, and after 3 years, they're destroyed. So that means law enforcement will never get access to this record. Okay, the court should not have access to this record, and this is a complete and total sealing, and this is the only avenue to get this in the state of California. The other remedy that you can pursue with regard to an arrest is more of a new law. It's California Penal Code Section 859.91. It's also called sealing your arrest. However, this doesn't require that you prove that there was no reasonable basis for your arrest or that you're actually factually innocent. Rather, what it requires is that after the arrest, the district attorney either does not file the case and the statute of limitations is expired, meaning for every case, there's a statute of limitations. I mean, for every crime, there's a statute of limitations. So most misdemeanors, it's 1 year. A lot of felonies, it's 3 years or longer. So the statute of limitations for whatever crime you're arrested for has to expire. Or if it hasn't expired yet, you have to show that it's in the interest of justice to have your arrest record sealed. However, in this case, the sealing of your arrest is a very limited sealing, okay? Because it is not sealed as to the law enforcement agency, meaning the law enforcement agency that arrested you is not going to destroy or seal that record, okay? The court record is actually not entirely sealed, nor is the Department of Justice record actually sealed. So what does this actually do if none of those things are actually sealed? Well, it does seal with respect to the background check companies. As a practical matter, that's really all of it does. So certainly nowhere as good as a factual innocence finding, but it has limited benefit. It's certainly better than not having it, and I have a lot of clients that do pursue that. Okay, so that basically covers the issue of how do you seal or destroy any kind of arrest record. But let's just say again that you go to court, you're arrested, the case is filed, and now you were actually convicted of something, meaning you were found guilty of something. So there's a number of remedies to pursue there. So let's say you were convicted of a felony. Let's say you were convicted of felony Penal Code Section 273.5, which is a domestic violence battery with injury, okay? And that particular offense is what's called a wobbler, which means it can either be charged and found guilty or result in a guilty finding as a felony or a misdemeanor. Okay, so because it can be either or, if the ultimate finding of guilt or conviction is for a felony, then after that occurs, either during the case or any time after the case, a judge or the district attorney can, via Penal Code Section 17B, reduce that to a misdemeanor for all purposes. So let's say in this case you're convicted for 273.5, and then a year later, let's say you're still on probation, you want to have that reduced to a misdemeanor. And why would you want to have that? Because a lot of jobs, just as a matter of policy, will not hire anyone who has a felony conviction. So if the judge agrees through 17B to reduce that to a misdemeanor, it's a misdemeanor for all purposes in the future. Okay, so that's certainly something to pursue. Similarly, if some statutes are either infractions, which are also criminal offenses. Some people don't know that, but they're typically associated with traffic offenses, but also normal criminal court offenses sometimes are infractions. Some cases, some statutes, for instance, a 415, Penal Code Section 415, which is a disturbing the peace, can either be a misdemeanor or an infraction. So again, after the case, let's say you're convicted of a misdemeanor disturbing the peace, at any point after that, a judge can agree to reduce that to an infraction via 17D. So that is a wobbler as to being a misdemeanor or an infraction. Okay, so then the other remedy that I want to talk about is, let's say you were put on probation for, again, 273.5. Let's say in this case it was for a misdemeanor, okay? You can have your probation terminated early via Penal Code Section 1203.3 if the judge believes termination of probation is, quote, in the interest of justice. And what is the interest of justice? Well, what I've seen is judges will consider, assuming you've been on probation for a sufficient period of time, and assuming you've done everything in terms of your sentence that's required. That includes if you were required to do jail time or community service or classes or pay fines. You have to do that or the judge won't consider. But if you do that, the judge will consider you terminating for early if typically you've done about half the term of your probation, or in extraordinary circumstances even less than that, if it's in the interest of justice. And usually what you want to show to the judge is that you're being discriminated against because employers are permitted to use your conviction against you and are doing that, and you're unable to get a better job or even get a job, period. And if you show proof of that and you've done everything else you had to do and you've done some time, the judges are pretty amenable to agreeing to terminate your probation early. Now, the probation department can take a position opposing that, so can the district attorney, and often they do. But it's up to the judge. The other remedy that I want to talk about is what you would probably see if you were to Google clean your record or the word expungement, and that's California Penal Code Section 1203.4. Some people refer to this section as an expungement. You can if you want, but it's not really an expungement because there is literally nothing that is erased in terms of your criminal record if you get this done. And this is, again, pursued in a case where you've been convicted, and in order to be eligible for this, you have to be off probation. So let's say you're on probation, you can file a motion to terminate probation early, and at the same time, a motion, I will call this a post-conviction dismissal. If you want to, you can call it an expungement. And what this does is it allows you to honestly answer in any job application in the state of California that you have not been convicted of a crime if the court grants this. And as a practical matter, background check companies do not tell the employer if this has been granted and they see this in the background. But again, it is not a question of being erased. Nothing is erased. Rather, after this procedure is done, you're allowed to withdraw your formally entered no contest or guilty plea, and then a not guilty plea is entered and the case is dismissed. And then in terms of your criminal record, if you were to look at it, it then says 1203.4 dismissal. Okay, there's a lot of benefits of this though. As a practical matter for jobs in the state of California, it basically gives you back a clean record in the sense that assuming a background check company is doing the background check, they will not tell the employer you have any background if it's been dismissed pursuant to 1203.4. Now, if an employer were to consider a dismissed case, dismissed via 1203.4, they're actually guilty of a misdemeanor. So they do not do that. And so as a practical matter, it's a very good outcome. Now, I want to say in regards to this and in regards to anything I've talked about, these laws in terms of what employers can use against an applicant only and exclusively govern California employers. So, for instance, I know for a fact, because some of my clients have applied in other states, that some states allow applicants to use any kind of background information from whatever state, whether someone has had that dismissed pursuant to 1203.4, or whether there's been a 17B reduction from a felony to a misdemeanor, or 17D reduction from misdemeanor to infraction, etc. All of that can be considered. Okay, so I just want to let you know that this does not restrict out-of-state employers from acting. The final remedy I want to talk about, which is a pretty new remedy, is Penal Code Section 1473.7, which allows you to actually remove entirely a conviction after you've been convicted for a couple reasons. One is if you were not properly advised of immigration consequences by your attorney, or even if your attorney failed to pursue immigration-safe alternatives. So many crimes have, if you're convicted, have devastating immigration consequences, which include removal from the country and exclusion from ever entering the country again. Attorneys are required by law to inform their clients of the potential consequences, and they're required by law in the state of California to try to pursue a conviction that would not have that outcome, because not all convictions have that outcome. If either of those things didn't occur, this remedy allows you, if you file this in court and prove that, to vacate the entire conviction. And so what that means is, let's say you're convicted, and let's say you're facing deportation because of the fact that what you were convicted of is a removable offense. For instance, 273.5, domestic violence, is a removable offense. And let's say your attorney did not properly advise you of the consequence of that and did not attempt to get something that was not a deportable offense, for instance, like a 415, disturbing the peace. Well, then you'd have a very good 1473.7 motion. The other way to pursue a 1473.7 motion is if you're actually factually innocent and there's no evidence of that. So I think that's pretty much covered most of the areas that I see in terms of how do you clean up your record in the state of California. I will be making individual videos on each of these areas. Take care and all the best.